Thank you, counsel. Mr. Waxman?
Mr. Chief Justice, and may it please the court, just to clarify one thing, the statutory standard in Alabama for prong one is substantially sub-average intellectual functioning. Now, courts sometimes use the term, and properly so, true IQ of 70 or below, but every court in Alabama and this court and every other court in every other state that I am aware of understands that raw observed test scores is not the definition of true IQ. Now, in deciding whether a defendant has carried his burden to prove that he suffers from substantially sub-average intellectual functioning, Alabama law, like that of nearly all other states with the qualified, sometimes exception of Oklahoma, requires courts to evaluate all probative evidence as to intellectual functioning offered by either side. That includes evidence of intellectual functioning other than IQ test scores, at least where a court, considering expert testimony, concludes that those scores alone don't decide the issue. The courts below did exactly that by evaluating evidence of Smith's significant impairment on other neuropsychological tests of intelligence. This is pages 88 and 90 to 92 of the petition appendix. His grade school records, which showed that on every measure he was 2 to 4 years below grade average, culminating in a diagnosis of mental retardation in the 7th grade. When the warden and the solicitor general ask you to reverse the lower court's faithful application of Alabama law, and I am holding all 12 reported cases on this issue post-Hall in Alabama, and there is not a single case, including the 2 that my friend mentioned, in which the court said, we're only going to look at the test scores, we are not going to consider other evidence. In Perkins itself, which is the lead Supreme Court case, I'm sorry.
Thank you.
Before you go on to the another granular argument, what is precisely, to your understanding, is Alabama law?
Alabama law.
Just the pure law, not this case. What does it require?
Alabama law requires that in evaluating whether an individual is intellectually disabled, 3 prongs must be met: substantially sub-average intellectual functioning, substantially sub-average adaptive functioning, and onset before the age of 18. And the Alabama Supreme Court in Smith versus State specifically said and subsequently repeated that the Alabama legislature has adopted the most liberal definition of intellectual disability for purposes of the Eighth Amendment.
Excuse me, but do you agree that compliance with Alabama law would be compliance with the Eighth Amendment?
In this instance, yes. I could imagine a situation in which, Alabama said, we're just never going to execute anybody who gets a score. Well, let me just put it a different
way. Do you think that the statement, in theory, the pure Alabama law, not an application year, is enough to comply with the Eighth Amendment?
In this sense, given the way that Alabama has defined intellectual disability, yes.
Okay.
In other words, to go to Justice Gorsuch's question of both of my friends earlier, of course a federal court, and here a court is not sitting, this is not a post-conviction, EDPA-type review. The trial court never held this hearing and heard this evidence. It is certainly true that a federal court cannot reverse a state sentence unless it violates the Constitution. That is exactly what both lower courts held, and that is got to be the case because, as Atkins explains, federal constitutional law in this area incorporates state law.
Do you think the Eighth